Adjournment matter may fixed after 2 weeks, Lordship.
Why?
Due to personal difficulties of my senior Mr. J. Ahmed.
Huh?
Mr. J. Ahmed, he is not available.
Gilidari Nadwar means meeting. What is the matter?
I am not aware about the fact. I am appearing on behalf of Mr. J. Ahmed.
What happened to Jay Ahmed?
He is not,
Well,
yes.
he's not well.
Yes, sir.
On the ground that Mr. J. Ahmed, learned counsel for the petitioner, is not keeping well. He is unwell, huh? Come on, Mr. Huh?
R.A. Ahmed.
R.A. Ahmed made a mention on his behalf that matter be adjourned for 3 weeks. Mr. R.R. Gogoi, learned standing counsel, Forest, has no objection. Mr. Therefore, prayer a lot. List the matter after 3 weeks.
May I please, Your Lordship? What we consider the other side, I beg to mention item number 10, Your Lordship. In this matter, Mr. D. Gogoi, he was supposed to appear, but due to some personal difficulty, last night he has to go out of station, Your Lordship.
D. Gogoi, what is the matter here?
Yeah, this matter is regarding a challenge to an order of the civil court, Your Lordship.
Huh?
It's a challenge to an order of the session court, Your Lordship. Confiscation proceeding, Your Lordship. Confiscation proceeding.
What?
Confiscation proceeding.
Confiscation?
Yes, Your Lordship.
Why writ petition?
That's why the reason is that's why they have filed a writ petition challenging that order, Your Lordship.
Why
Order of the
writ
civil
petition?
court.
Why writ petition?
So they have to answer why they filed.
Anyway, on the prayer of Mr. R.R. Gogoi, learned counsel, appearing on behalf of Mr.
D. Gogoi.
B.
D.
D. Gogoi, learned counsel for respondent,
For the Forest Department, Lordship.
for appearing for Forest Department. Come, list this matter after
Any date, Your Lordship.
3 weeks.
I'm highly obliged.
May I please, my lord? Would you consent of the other side? I beg to mention item number 3 of the daily list, my lord.
Why 3?
My lord, here the signing authority, my lord, the signing officer, he has to come from Dhekia Zone. Today, due to some personal difficulty, he couldn't come. But we were supposed to file the affidavit today. My lord, may I prefer taking up this matter next week, my lord? We'll file our affidavit.
May I please, Your Lordship?
Yes.
Due to the goods are seized are of perishable nature, so kindly a short on next week 18 it may be listed. Your
What is the
Lordship.
matter?
My
Your,
lord,
Your Lordship, we were purchasing some goods and our truck were seized and truck were stopped and notice was given and goods also were seized, Your Lordship. So, Your Lordship, they are perishable.
On the prayer of Mr.
8 Purva, my lord.
learned counsel for the respondent. List this matter after a week so as to enable him to file affidavit in opposition.
18th, Your Lordship.
After a week, Mr. M.S. so-and-so learned counsel for the petitioner is present. SS, your name?
P. Sharma, Your Lordship, kindly a date may be given as the goods are in.
Next week, after a week, will be taken up. List after a week, when?
Your Lordship, it will kindly consider.
What sort of goods, perishable goods?
Pan masala.
Pan masala, it's not a perishable.
Kindly 20 on 20, Your Lordship.
Pan masala, it's not a perishable goods.
But they are.
But it was seized.
It's been almost, I don't remember, but it has been already time,
Anyway,
Your Lordship, on 20. Kindly consider, Your Lordship. 20 on 20.
Obliged, my lord.
May I please? I beg to mention item number 9 and 10. I have taken consent for the other side. I am for the respondent hearing, respondent number
10 already mentioned.
9.
So,
So in this regard, we have supposed to file our affidavit.
what affidavit?
The amendment petition is filed by the petitioner. So some time may be granted.
Affidavit in reply.
No, opposition.
You are for?
I'm for respondent, 9 and 10, on behalf of Mr. P.D. Nair.
On the prayer of Mr. So-and-so appearing on behalf of Mr. P.D. Nair, Learned Counsel for respond number 10 and 11. List this matter after 3 weeks so as to enable the respondents to file their affidavit.
Obligation.
Today's Delhi court days, admission item 2.
Here, part payment has been made by the respondents. And your lordship, there's a amount of 28 lakhs 2,092 is due.
Hmm. So you have received 24/7.
Yes, your lordship, I have received 21,49,794.
Not 24 lakhs.
No, 21,49,794.
Huh.
Received after filing of the writ petition.
Yeah. So what about this 24/75? Out of this 20,
50% is 24,75,943. That they have received already. The rest part, that is the 50%, that 24,075,943, it is already been the bill has already been submitted at the dispute treasury, white bill dated so and so, and the status of the bill is still showing as pending. So let us wait for some more
Lordship,
time.
on the last occasion.
that's the last occasion, same submission has been
Yes.
made.
And prior to the day made the submission, then after 11, the funds will go, my lord.
This is dated 6/3/2025.
7/3 we have passed the order. It was listed on 7/3.
I have to wait. We have to.
They said after 11, it will go away. The fund will be.
Check portion.
Yeah, no, of course. No, we have not received it.
Then I have to take the instruction, Lordship. Thereafter, Lordship.
Sir, it was only on same submission we passed the order
Yes,
on
yes, yes,
7. We have adjourned the matter for today.
Lordship, let the matter be fixed after 2 weeks, Lordship.
Lordship,
Let me.
It would be. of
Because this is the month of March, Lordship. Most probably by this month, Lordship, it will be ready.
Lordship, may I
That's
pray?
because it is in the treasury.
So why don't you get a simple instruction? Why couldn't get a simple instruction? That was a submission made on 7.
Lordship.
Your communication is on the basis of that only.
So,
It's of
I'm
6.
extremely sorry, Lordship. I have not gone through that
6 file.
order.
You must go through this. This is particularly for on your submission only, same
Yes,
submission
yes,
we have
Yes.
fixed the matter today.
Yes.
Lordship, may I pray? Direction may be given to them to release the amount in favor of me, and whatever would be the disputed amount, my lord, whatever they have not sanctioned it,
We'll say,
I'll
yes.
approach the appropriate forum.
The ceiling amount has already been, it is lying in the dispute treasury and the. So most probably within this month, Lordship, it will be. পাবো? বলে মঞ্জিত চেতিয়ালি নাইনি গিয়ে
Or Miss MS B. Buya, Learned Counsel for the, we're disposing of it of, you pay within 15 days.
Lordship,
Because
in fact,
it's been-
In fact, Lordship, in this matter, Finance Department has already given its approval.
It's okay.
It has been.
That's
forwarded
all,
to the treasurer, sir.
In view of that only we're disposing it of.
In my understanding, Lordship, it is the petitioner who should take the instruction whether it has gone to his account or
No,
not.
it has not
That's
been gone.
the submission, it's not.
It's very recent, Lordship, 6/3.
No, that's why it's on 7, we have fixed the matter for today only. So we're disposing of the matter in view of your submission, you pay within 15 days. Because it's in the treasury, whatever amounts is which you have admitted, 24 lakhs 75,943.
Lordship.
Yes,
In that.
And other,
No,
her claim is more than that, so we'll provide that she may avail the appropriate
Lordship will-
remedy.
Lordship will, in that case, Lordship will take up this matter on Tuesday. Lordship will obtain instruction from the Treasury, Lordship. What is, why?
No, that's why on the same submission, this order was passed, this matter was listed on 7th.
Yes. Lord. So it was to the government, Lordship. I'm appearing for the Treasury officer also. On Tuesday only, Lordship. Tuesday, I will place the.
What's that? Who has to
No,
pay?
if for some reason, Lordship, it has been rejected, that will not be possible in this financial year. That is why I am praying
No.
for that particular.
We'll just say, it's been received and deposited in the treasury. So it's a question of rejection. Today is what?
Today is
13th.
13.
Okay, Lord. I'm praying only. for
Let the
Monday,
order be
Tuesday.
passed, your lordship,
By 31st. By 31st you pay.
lordship, 35 will
Because-
be too
31st is same thing.
The 31st will be too late. She is right.
late.
That will be a year ending.
Hmm?
So that is why I am only praying for 2 days time, Lord. On Monday or Tuesday, Lordship, I will inform your Lordship. If-
What info, what more you have deposited and
No,
finance
if
has
it-
already
if it is
released.
Not yet, it has not yet gone to the account of the petitioner, then what is the reason?
If
That's
it,
my
if it is gone, Bata would have had,
In
and
my
there-
understanding, it should go. In the meantime, it has already gone. That is my understanding.
we'll say, if it is not deposited or released to the account of the petitioner,
Yes.
within 15 days you pay.
And
No,
lordship
if-
may keep the matter
That
pending.
that
my
is the reason, Lordship. If
Hmm.
for some reason it was returned, Lordship, in that case, the difficulty will arise.
So,
Only 2 days time I am praying, Lordship. On Monday, Tuesday, any day, Lordship.
sir, the claim is something else. You have admitted some amount.
Lordship will take up this matter at 2 then. I
Huh?
will take the instruction from the treasury officer
Two.
at 2.
Will t- Because they are unnecessary, we're fixing the matter every day
At 2, Lordship.
at 2. Supplementary assembly.
Supplementary for this orders items here.
Supplementary. What is supplementary?
Make
Yes.
So the petitioner filed an petition challenging the cancellation of the tender process. After the tender was opened, tech level bid, financial bid, the petitioner was declared to be L1. And after declaration of the L1, without any reasons, the tender process was cancelled. The petitioner approached this honorable court, and this honorable court issued notice and directed that no fresh tender should be issued without leave of the court. Now, my lord, without taking leave of the court, a fresh tender has been issued. Now, in the fresh tender, the eligibility criteria has been given in such a way that the petitioner will be out. Although the quantity earlier was 40,000, now 30,000, but the same subject matter same, the tender has been issued without leave of the court. So
Earlier this was 40,000.
well, quantity was different, but ultimately quantity they may go on 20,000, 30,000. But the earlier tender when cancel was there and it was said, my lord, that fresh tenders can be issued only should not be issued without leave of the court. How the fresh tender can be issued without leave of
Where's
the
the
court?
other side? Railway.
That's why I filed an intellectual application, my lord, that the fresh tender process, they should not proceed with.
Have you furnished the copy?
Yes, yes.
State lady. We'll record it and we'll state,
That's why I'm not,
but we'll not dispose of the IE.
no.
In the meantime, in view of the order of the earlier order passed by this court earlier.
Let them come up with their
Yes.
submissions.
And Mr. Dr. S. Arap, Learned Senior Counsel, assisted by this. None appears for the petitioner. Despite service of notice to the Learned Council, Learned Standing Council Railway. List of Union of India also you have,
Well, Union of India will have to make a party because railways is there.
no, have you furnished the
Yes, yes,
copy?
yes.
All,
We have.
none appears for the parties, respondents, opposite party respondents. Despite service of notice to the Learned Council for the service of, despite furnishing of copies to the Learned Council for the opposite party respondents. This entry application is filed praying for bringing on record the subsequent development as well and for staying the press bid dated 18/02/2025. Please stop.
One number may also be mentioned below.
Press
The-
bid number so and so, page 1. GEM so and so so and so. Please stop.
The earlier order is at page 14 below.
14.
Operative portion is at page 17, 16 start last.
The petitioners, the applicants,
Petitioners.
applicants oblique petitioners. Comma, agreed by the cancellation of the tender process bearing number GEM/2024 B481091 dated 23/03/2024. This is for what? For
Below for supply of care.
supply.
Supply of.
Supply of cable.
Supply of cables below.
Where it is?
Below this.
Where do you get this?
With it will also find.
Have you stated the effects? By the general manager of the construction NF Railways for supply of
In the petition, it is
Ah.
33 below.
page 5, para 2, supply of cable for core 70 square meters, so and so, para 2, you just keep that. Which has been registered in the being WPC number 6846 of 2024. This court will issue notice by an order dated 20/12/2024 on consideration to the consideration of the submissions of the parties as directed the NF Railways do not upload fresh tender in respect of the work bearing bid number so and so dated 22/03/2024 issued by the general manager construction NF Railway without leave of the court. List of the respondent railway authorities where is the fresh bid?
You'll also find.
20, page
Page
20
Page 20.
by impugned press bid dated 18/02/2025. Issued
In respect to
April.
same item.
press bid in respect of same item, namely, page 20, cable for so and so, for a quantity of 30,000,
Well,
although in the
42.
earlier tender, the quantity was
42,000.
quantities were 40,000,
42.
42,000. Mr. issue notice to the, will issue notice to the respondent. Issue notice to the, you are for?
CGC Lordship on behalf of H Gupta Lordship. I
Okay,
accept the-
then CGC, huh? You record CGC. For respondent number 1, huh? Then you said dispatch so and so non appears for so and so for other respondent, opposite party respond, 2 and 3, huh? Issue notice to the respondents. Mr. Having,
For all the respondents.
huh?
Union of India Lordship, I am appearing for all the respondents.
Is it?
Yes, Your Lordship. Railway,
Nowadays, separate railway council is not there, my lord.
the CGC accept the notice.
No, we have noticed that there are standing council railways
Lordship, CGCs are the standing now.
to all.
Yes.
And in that case, notice is not
Lordship.
required. Then for all the opposite parties, you delete that despite notice and all. Huh? Since then thereafter you write, since Mr. So and so appears for so and so, no formal notice to be there, need be served. Next. Where is staying this fresh
Lordship,
tender? Having considered the submissions of learned counsel for the parties and also considering that this court has clearly directed the railway authorities, NF Railways, not to upload fresh tender in respect of the bid dated 22/03/2024. Comma, order leave of the court, comma. I'm of the view that the press tender, the impugned press tender being GM so and so, huh? Dated 18/02/2025 is required to be stated accordingly. The impugned tender, GM, fresh tender, GM being GM so and so, dated 18/02/2025 is hereby state. List after 3 weeks.
Well, I have received instruction, well, actually.
You have missed the bus. You file appropriate application.
Well, I have the instruction, my lord.
Saying what?
Well, this is a national project, my lord, the project should not be stalled. And this tender process is a separate tender. It's not related to
You
that.
file the appropriate application. While fixing it after 2 weeks.
My lord will issue notice at least. And without hearing, my lord will not stay, my lord, because it's a national project.
I have heard him. He is for CGC.
My lord, my instructions are there, my lord.
You
Otherwise,
you file an application. We'll see. List the matter, after next para, huh? After
No,
passing of the interim order, after consideration, after hearing of the matter, interview application, Mr.
H. Gupta, my lord.
H. Gupta, London Standing Counsel for NF Railway, appeared and submits that since it is a national project and the impugned tender that is so and so,
Is not separate, my lord.
1812 is a separate
Tender. my lord.
separate tender. Mr. Having considered the materials as annexed in the writ petition as well as the present interlocutory application, comma. The Mr. H. Gupta is granted 2 weeks time to file appropriate
Not a week's time.
application.
But because we'll file affidavit, my lord, we take it to
List the
final
matter after
disposal, my lord. Date may be fixed, my lord.
2 weeks. 2 weeks, we're taking it up 2 weeks.
Date may be fixed, my lord.
It's okay.
Earlier one council is saying that I'm appearing.
Yes.
After some other council is saying I'm
No, no,
appearing.
no,
That's why I don't want to, I mean, that's why I've recorded his presence.
Well, how it can be, my lord, that
Yes.
one council has argued.
No,
Another council
I'm not
says-
arguing lordship because lordship has called me, that's why I came.
He said I'm appearing on behalf of the.
Yes.
I have accepted the notice, lordship. I have only accepted it because my friend is here, lordship, because he is appearing earlier.
I
case
have
also.
the-
It's okay, we'll take it up
My
after
lord,
2
we'll
weeks.
Fix a date, my lord.
You show, if you can show that this is a separate
Yes.
order,
Prima facie,
we'll,
it's a separate matter.
we'll vacate it
Yes.
My lord will fix the matter, my lord.
after 2 weeks.
Let
Date
them
will
file
be-
it, definitely they can
Ah.
mention it.
You
Well,
file it,
ultimately,
make-
the project is stalled, my lord. It's a.
No, we don't want to stall the
No.
project, but then we'll see.
My lord.
It appears to be same, same.
No, no, it's a separate requirement, new requirement. This is a section which I have received. my lord.
Okay, you bring on record, we'll consider it. It's not that we'll,
That's why I am praying for a week's time only. my
after
lord.
2 weeks. We'll take it up after 2 weeks.
Item 13.
May it please, your lord. There's a small correction, my lord, in the writ petition, my lord. There is a mistake, my lord. Page 3, my lord.
Hmm.
Page 3. The petitioner's name, my lord. It was wrongly shown as, my lord, Nagarjar Children's Club and Library, my lord. It ought to have been, my lord, Nagarjar, my lord, Naujawan Club, my lord,
Heard Mr.
Anjay Dutt.
Who is appearing for the state? State is there. Learned counsel for the applicant petitioner. And Mr.
H1.
H. Sharma, learned state counsel for response. Petitioners, huh? Not petitioners, petitioners, huh? By filing this application, petitioner has sought for correction of the petition number 1, name of the petitioner number 1. Mr.
Page 3.
Petitioner is the name of the petitioner has been wrongly, inadvertently written as Nagarjar Children's Club and Library, which ought to have been Nagarjar
Naujawan Club.
No Journal Club. Where
Club
it
and
is? Para?
My lord, page 3, my lord, of the writ petition.
No, no. In your this IA,
I am, my lord, my lord, page number 6, my lord,
okay.
page number
Nagarjar
6.
Children's Club. Only the children's club, it should be in place of children's club, it should be Naujawan.
Yes, ma'am, that much.
Okay. Mr. Having considered the writ petition and the submissions of learned counsel for the parties. The no, having considered the writ petition and the submissions of learned counsel for the parties, I deem it appropriate to allow this the introductory application list accordingly. The name of petitioner number 1 may be corrected as Nagarjar Naujawan Club and Library instead of Nagarjar Children's Club and Library. That's all.
That's
The IA instance allowed and disposed of.
my lord, can I,
In will say no, you file an amended the in writ petition, huh? In view of the order passed in IA so and so, the learned counsel for the petitioner is permitted to file. The learned counsel for the petitioner is to file amended cost title, placing amended cost title, accordingly. Please, the registry to incorporate the correct the name of the petition number 1, Mr. That's all.
I'm obliged, deeply obliged.
Lordship,
Hmm.
sorry, my matter was fixed at 2 o'clock.
Hmm.
Just now I received an instruction from my client, my lord. An amount of 21,49,793 has been credited in his account at 10:14 a.m. today. Lordship, for rest of the amounts, my client still has got claims, my lord, because they have not disputed the amount. Let the matter be pending, matter be fixed after a week, your lordship.
No, why they are paying,
Only 21
In-
out of
in
24.
huh?
Out of 24, they have paid only 21. Their instruction
Yeah.
was that 75,943 has been credited.
Friend Lordship. we
So
did
we're,
take
we're
for the-
fixing it on Tuesday, you
Yes.
clarify.
Right.
Heard MS B. Buya, Learned Counsel for the petitioner. It is submitted by MS Buya, Learned Senior Counselor, assisted by so and so.
JPAS.
Learned Senior Counsel that the petitioner has received an amount of
21
rupees
lakhs?
21 lakhs
49,793
49,793
today, my lord, at 10:14
at
a.m.
today at 10:41 a.m. 10:41
10:14.
at 10:14 a.m. List of having considered that the communication dated 06/03/2025 indicated that the admitted amount of rupees 24 reflects that the admitted amount of rupees 24,75,943 has already been submitted at dispute treasury on 01/03/2025. The learned
No, Lordship, the Mr. Nayak, he is appearing
in
for
the other court.
treasury
You
officer.
tell him, you
I
tell
from
him,
him.
He will be able
Mr.
to.
P. Nayak, learned counsel appearing for learned standing counsel finance and taxation.
Fine, very-
Finance and taxation as well as for treasury,
Yes, Lordship, treasury.
as well as treasury, is directed to obtain instruction by next Tuesday. List the matter on Tuesday.
18th.
18th.
Of
You
that.
just find out.
Lordship.
Ready for this hearing item 4.
Before coming to this, I pray for adjournment for today also.
Why?
Also, the English Council, Mr. Abraham has been engaged on a proposed seminar on LAC on new criminal laws. Proposed seminar on criminal laws. So he has been engaged. Also, kindly grant us some time. Also, they have filed the additional affidavit bills.
I didn't get what?
Also, they have filed the.
No, what you have said.
Notice English Council has been, he has been engaged on a proposed seminar on a new criminal laws in LAC. LAC, Lawyers Association Guwahati. So he has been engaged on, due to that difficulty, we pray for adjournment for today also.
Which has to be given preference?
Lordship also.
The High Court or your seminar? Seminar is equally important, but which has to be given preference?
High Court.
Then
Lordship also, they have filed the additional affidavits. We will, if possible, we will file a response, Lordship.
not possible. Don't make a mention like that. Yes, what is the matter?
Meta, my lord, we, my lord, purchased one plot of land, my lord, in the year 71, my lord, 73. Yeah. In the year 73, my lord. 1973, it was purchased, my lord. But that was purchased from the, my lord, tenant, my lord. It is like that, my lord, occupancy tenant, my lord. I have purchased the land, my lord, from the occupancy tenant, my lord. Subsequently, it was, my lord, the due process, my lord, they have cancelled the said, my lord, order, my lord, of the our, my lord, sale, the etc. everything, my lord. In the court of, before the, my lord, settlement officer here, in the additional deputy commissioner, in the lower court, my lord, in the deputy commissioner office, my lord. Subsequently, we shall, they said, before the revenue board, my lord. and revenue board ex parte order passed, my lord, affirming the order of the, my lord, learned additional deputy commissioner.
The notice they have, so they have received the notice lots, but at the same time, without knowledge and without the information, they have sold the said land. to
What
the-
is the additional affidavit?
Additional affidavit bringing on record, my lord, regarding the, my lord,
Heard Mr. So-and-so, learned counsel for the petitioner,
S.A.
Mr.
S.A. Bhatia.
S.K. Bhatia,
S.A. Bhatia.
S.A. Bhatia, learned counsel for the respondent number
6 to 11.
6 to 11. Press submits that he may be granted some time to respond to the additional affidavit filed by the petitioner. Please stop. What about the state? Challenges against the action of the state?
The order passed
You
by
have filed the
Revenue
affidavit.
Board, Lord.
You
We are
have-
there, Lordship. Our order has been upheld by the Revenue Board,
Revenue.
challenging them.
Praise the Lord, list the matter after
3 weeks.
3 weeks. So as to enable the learned counsel for the respondent number 6 to 10
Yeah.
to file
6 to 11.
to file response to the additional affidavit.
Not surprised.
Your Worship.
I can file.
May I please, your lordship, lordship,
Yes.
it's the order, it's a covered case, lordship. In fact,
Mr.
lordship,
Kale
there
is
are,
on
there
lakes, lordship.
Huh?
Pass about the matter for time being, lordship. Lordship, Mr. Kale is on lakes, lordship.
just let me,
Yeah. KL,
lordship. Let me finish my, they can just verify whether it is covered or not, that is the only thing. Lordship,
this one, the Jyoti Labs,
Jyoti Labs, lordship, it is covered by Jyoti Labs,
you just give her,
give a copy to us. Lordship, they are only.
you
saying-
just give a copy to her and you apprise your senior, Mr. KL, whether this is a covered case or not.
Lordship, last time he
We'll
has,
take it after some time.
last time he had made a submission that it is almost, it's covered. But lordship, what we have done is that when we filed a special lit application, even though, because the court's order is that you consider the special lit application and in the meantime, there should be no recovery. That is the judgment. Lordship, in our case, what is it? The special lit application which we have filed,
What application?
special lit application,
Okay,
special lit application that we have filed, even though we have addressed it to the principal commission, that is to the correct authority, but we have filed it because that was COVID times. So we filed it, lordship, to their office. They said, "Oh, no, you have to come to Guwahati, file it over there only." And that is why, lordship, they are not considering. Otherwise, there were 70 to 80 cases, all have been considered. This is only pending only because of this. That you have filed it before your own Silchar office, but you have to come all the way to the Guwahati and then you have to file to the principal commissioner. Otherwise, if you have filed to Silchar, we have got the receipt of Silchar. They said that no, that will not suffice.
so you file here, what's the big deal?
That is what lordship may kindly give, that I will give a copy to them. Lordship, they may consider it. That is the only thing which we want. That
Not
we'll go.
copy,
with
you
copy.
file the appropriate application before them,
Lordship, then
before
then
at Guwahati.
condone the delay, lordship. The delay has been condoned in other cases also, lordship. We condone the delay and we'll file it and they may consider within a particular time frame. If you are eligible, they will give, otherwise not. That is the thing, lordship.
So basically, what is the challenge?
Lordship, we are challenging that, lordship, we had there was a notification, lordship, by the central government under the NEIP, by which the notification they had said that I curtail your benefits. 2007 was given, I curtail your benefits. You were earlier entitled to 100%, we will give you only 35%. Lordship, we won the matter before the Guwahati High Court. Ultimately, the matter went to Supreme Court. Supreme Court finally said, no, the curtailment is correct. The curtailment is the VVF Limited, lordship, judgment is there. I have annexed the VVF Limited judgment also with my petition. Lordship,
No, Jyoti Labs.
lordship, the Jyoti Labs finally came after the Supreme Court judgment. Lordship, we said now the Supreme Court has decided a issue. Now we will apply before the commissioner for special rate. Like somebody was given 36%, somebody was given 56%. My percentage, I don't know. So I will apply before the commissioner. So lordship, but they said that you are delayed in coming to me for filing. This honorable court condoned all the delay. They said that, okay, it was COVID period, so I condone your delay. Like you are allowed to file the application and that may be considered by the commissioner on merits. So lordship, the delay was condoned. In fact, lordship, there was another judgment of this honorable court in Northeast High Tech, wherein the honorable High Court said that in this type of cases, there will be no time limit. You can file it. Because they have issued recovery notice. The court said that first you determine what is payable, exact payable by lordship. The special rate application may be decided, and thereafter you can recover the way you want. But till then, there will be stay. Thereafter, you determine what is the actual amount payable. Paragraph 7 onwards, lordship.
Which one?
Lordship, Jyoti Labs. In fact, paragraph 6. Lordship, on
An
an
appeal being carried before this.
lordship, by the department against the judgment of High Courts, which were in our favor. The judgment in Union of India (VVF) was passed, which is reported in so and so. By the said judgment, Supreme Court, the judgments of High Court interfering with the notification, and so was interfered, meaning thereby notification and so both stood restored. The petition is instituted on the grievance that since the notification dated so have been restored as per the judgment of Supreme Court, two application dated so of Central Excise Board dated so was submitted by the petitioner claiming for a special rate. But the same has not been given its consideration, and without giving a due consideration to the claim for special rate made by the petitioner, the respondent now intend to attach the bank accounts of the petition on the premises that refund of excise duty will be as per rates provided in the notification. As per notification provides for a legal right to the SEC to claim for a special rate to be fixed in the event of there being any add-ons to the goods manufactured. We are of the view that without any appropriate decisions being taken on such claim for special rate, it would be inappropriate for the department to proceed against the petitioner as per the rates in the notification dated so and so. In view of the above, as agreed by the learned counsel for the parties, this petition shall dispose of by directing the principal commissioner to consider the aforesaid application of petitioner claiming for special rate to be fixed on the basis of add-ons made on to the goods manufactured. After arriving at special rate, if any, as per the order to be passed by the principal commissioner GST, further process against the petitioner as per law may be initiated. Till such decision is taken, no coercive measure may be taken. The principal commissioner shall do the needful as indicated above within a period of 6 weeks. Further, in this petition, the petitioner also assailed the imposition of interest that the petitioner required to pay. As we have not decided this issue, liberty is granted. That is not important. So, lordship, they had allowed us to file special rate application, and that I have filed this special rate application before their department only, and was addressed to the lordship, the appropriate authority. The special rate application, your lordship will find at page 173. Earlier, lordship, they said that we did not receive, so we filed an additional affidavit also, showing the receipt that we have filed it to them. I have, lordship, page 173 to the commissioner. I have addressed to the correct person. But lordship, while filing, I have filed it because it was COVID times, lordship. So I have filed it in their office at Silchar, lordship. I have filed an additional affidavit showing the receipt of Silchar. They have admitted that yes, I have filed it on right time before Silchar authority, but they are saying that no, you should have filed it before the principal commissioner. That is the only issue.
Where is the notice? Impute notice?
Impugn lordship notices are lordship page 170.
You are agreed by this?
I'm agreed by this because without giving any consideration to my special rate application, they cannot.
Request for
recover.
payment of erroneous refund being 60% of the balance amount paid in current PL against payment of CEDT for the period from. They are seeking refund.
Lordship, I have already been paid a refund of amount.
Huh?
They are asking me a refund of some tax which they have paid to me. They are asking refund from me. This type of recovery which notice.
Repayment of erroneous refund.
Erroneous, yeah.
Okay.
Lordship, what is the amount which is to be refunded?
Hmm.
That is to be determined only after coming to a special rate, which I have filed in page 173. What is
Direct allow madam are hereby request to make payment of a person erroneously refunded emotions. Huh? Okay, 173 for fixation is special rating.
We said that you fix the special rate, then you determine the amount. That is my only consideration. The court has given in 70 to 80 cases.
Determine the special rate, then
Then you then thereafter, till then there will be recovery will be stayed. Thereafter you determine the amount and thereafter we will pay. But without determining my special rate, Lordship, the recovery cannot be done. This is the court's order, Lordship. This is a simple order. Now, Lordship, they are making it complicated by saying that, okay, you have addressed it to the right person. You have filed also to the to my department.
And
But
they are making an objection that you cannot file now.
no, we have filed in the right time. They are
No,
making
no,
an
suppose
objection.
if you have filed before the wrong forum, wrong authority, you have, what is the time frame for filing the
Lordship,
application?
it's lapsed long back. Lordship,
What
that
is
was-
the time frame?
the time frame is, Lordship, normally as per notification, it is within September of that year. But Lordship, this honorable court had condoned the delay because Supreme Court judgment came in 2020.
Hmm.
We have filed for 13, 14, 14, 15, 15, 16, long back. Though this honorable court had condoned the delay and thereafter allowed us to file application after the judgment of Supreme Court. In fact, Lordship, in one of the cases of Northeast High Tech, this honorable court, Justice Debashish Barwa's judgment is there. So compilation with Lordship, if I may be permitted to give the compilation of Northeast High Tech judgment. Patient को कैसे पता चलेगा? So the Northeast High Tech, the judgment is at page 74. Lordship, in this judgment, Lordship, the entire thing has been discussed. The judgment of Supreme Court and everything has been discussed. And finally, this honorable court has said only about the Lordship delay part. Ki, since the application has been filed delay, Lordship may kindly see paragraph 32, which is at page 39, internal page 38. Page 38, Lordship, may kindly see paragraph 32. This stage, it would be further relevant to mention that while an order dated 10th January 2022, Supreme Court had again restored the order dated so-and-so, and in continuance of subsequent order dated so-and-so, it was directed that period from so-and-so shall be excluded for the purpose of limitation as may be prescribed under any general or special laws in respect of judicial or quasi-judicial proceeding. It was further observed that where limitation would have expired during this period, notwithstanding the actual period of limitation, remaining all persons shall have limitation of 90 days from 1/3/2022. In view of the above, taking into consideration the judgment of Supreme Court in case of VVF Limited, Lordship, that's our judgment, the judgment of this court in Jyoti Labs Limited, the various orders passed by the Supreme Court in suo motu petition and the benefits thereof being given to the taxpayer by the GST Council, the circulars were issued from time to time, and also the judgment of Bombay High Court and Madras High Court, and taking into consideration that the petitioner's application were filed on 18/3/2021 for fixation of special rate for value addition. This court deems it appropriate and accordingly directs the Principal Commissioner of Central Excise and so Dibrugarh.
You have filed it, your application is 02/02/2021.
Before this, Lordship. Yes.
Hmm?
Yes, Your Lordship. 22/2/2021
During COVID.
during COVID, Lordship. So, Lordship, I cannot travel to Guwahati, so I filed it to their department. This is the inter-department issue, Lordship. They could have given it to their, they could have sent it to the Principal Commissioner and decided the issue. We cannot travel at that point of time. Further, taking into consideration that order in original has a direct correlation with the fixation of so-and-so, this court deems it appropriate and accordingly directs the concerned notary not to give effect to the order till such decision of respondent number 2 to the application filed by them. They have, Lordship, in view of this, the court has allowed the limitation period to be waived off and the application to be filed and to be considered by them. My only Lordship, I'm not asking anything. Only my special rate may be considered on merits. If I'm eligible, they may, Lordship, till then recovery may not be taken. That is the only judgment which Jyoti Labs judgment I am relying on. Lordship, this compilation consists of all the judgments of the Guwahati High Court which has been passed in the past. Other judgments are also there in this case.
We'll decide, if we agrees that it covers, then we'll pass order for 2 pages order.
Yes.
Huh?
It is covered, but only that portion may be kindly to consider by this.
After some time, call him.
Much obliged.
Item 6.
Yes.
My lord, this is a petition where I've challenged the impugned order where I have been blacklisted for a period of 5 years by the respondent authority.
Huh?
My lord, this is I'm challenging in this petition. I have challenged the impugned termination notice dated 17 December 2020, wherein I've been blacklisted for a period of 5 years from participating in any of the tender documents. My lord, the brief facts of the case is that there was a tender which was floated by the respondent authority on 14 November 2019. My lord, on 2nd June 2020, I was selected and a letter of award was issued in my favor. My lord, when the letter of award was given, as per a tender document, they verified all my documents. On 29 July 2020, I submitted a performance bank guarantee to the tune of 2,76,70,989. Lord, along with the tender, I submitted a earnest money deposit of 32,22,900. Lord. When they verified all my documents, they awarded the contract to me, issued a letter of award on June 2020. On July 2020, I submitted a performance bank guarantee also.
Why didn't you put on your button?
Lords. Apologies, Lord. Milord, then after 6 months, when letter of award was given, I mobilized my resources for the execution of the works, Milord. After 6 months, when I mobilized my resources on 1st December 2020, they issued a show cause notice to me saying that the document of credentials submitted by the petitioner upon verification found to be not in the order and not found in the record of the DDA, Delhi Development Authority, and sought that and issued a show cause notice why action should not be taken. Milords, immediately when I received the show cause notice, I responded to the show cause notice on 11 December 2020 that and clarified that old document was inadvertently placed by the petitioner staff and it went unverified due to paucity of time. However, the petitioner requested a respondent to rectify the mistake and allow him to submit another document of credentials in the form of certificate of completion issued by the NHIDSL. Milord, it is permitted as per the clause 62(1)(14)(b)(f) of the contract. Milord, it is permitted. They did not consider this when I submitted this, Milord. They issued a termination notice on 17 December. They did not even, in the termination notice, they did not even mention about what if I can submit that additional credential documents. They did not. I mobilized my resources.
After the contract is awarded.
Yes, Milord.
It is permissible.
Milord,
to provide a.
Milord, it is there mentioned in the contract, Milord. Clause 62(1).
Yes, proceed.
14(b). It is permissible, Milord. It is mentioned in their own document, Milord. They terminated the contract, Milord. They forfeited my earnest money deposit. They forfeited my performance bank guarantee, and they debarred me for the period of 5 years, Milord. Thereafter, I challenged that before this lordship, before this honorable court, and then the honorable court was of the view that yes, they should have considered, and I was granted a stay on this. But the contract, they were given a liberty, they can proceed with awarding the contract to some other third party. That document was not stayed. But debarment was stayed by this honorable court. Milord, let me now, if your lordship may permit, let me show how they have been wrong, Milord. Let me show. First is failure to verify the documents of credential at the time of evaluation of the tender documents. The tender document was issued in the year. Tender document was issued in 2019, and I submitted my bid. They verified all the documents, and they had ample time. If they found any mistake that the document which I submitted there is some error, they could have rejected my tender document. This is mentioned in the tender document itself that if any document is found to be not genuine or if there is any defect in the document, the tender is liable to be rejected. Maximum penalty they could have imposed me at that point of time was they could have, if they found that any of the documents submitted by me is not right, they could have forfeited my earnest money deposit. What they did is they allowed me to, they issued a letter of award, and after 6 months, after issuance of letter of award, they said that, oh, we are re-verifying the documents, and we found that one of the document is not right, and therefore we are terminating. Second, Milord, if they had informed me at that point of time when the document was submitted at the time of bidding, I would have replaced the document. I would have issued the other document, my lord. My lord, thereafter, then, my lord, petitioner was not provided with that opportunity to rectify their mistake. My lord, kindly have a look at the page 91 of the reply to the petition filed by the respondent, my lord. Page 91, my lord. Of their reply, my counter.
90?
My lord, give me.
91.
My lord, page 149 of the running page of the court. On the report.
149. Yes.
62-114, my lord. My lord has it.
Hmm.
My lord, if you 62-114B, if the contractor failed to give at the time of submitting the said tender, let's come directly to subclause F. Submit copy of the fake document certificate in support of credentials submitted by the tenderer. Then in any of the said clause, the engineer on behalf of the railway may serve the contractor with a notice in writing to that effect. My lord has it.
That's right. Employment and partnership. Well, to give at the time of submitting the said tender. What does it mean?
62-114. At any time after a tender letter, the contract has been signed and submitted by the contractor, being a partnership firm, admit as one of its partners employee under it, or being incorporated company, elect or nominate or allowed to act as one of its director or employee under it any capacity whatsoever, any retired engineer of the gazetted rank or any other retired gazetted officer working with this before retirement, whether in the executive or administrative capacity, whether holding any pensionable post or not, in the railways for the time being, owned by and administered by the President of India, before the expiry of 1 year from the date of retirement from the said service of such engineer, unless such engineer or officer has shown permission from the President of India or any officer duly authorized by him on this behalf to become a partner as a director, to become employment, to take employment under the contract as the case may be, or fail to give at the time of submitting the said tender. Then there are conditions mentioned at the time of submitting the tender.
Or fail to give at the time of submitting the said tender.
Subclause F. Submit copy of fake document or certificate in support of credentials submitted by the tenderer. Then in any of the said clause, the engineer on behalf of the railways may serve the contractor with a notice in writing to that effect. And if the contractor does not within 7 days after delivery to him of such notice proceed to make good his default, I should have been given 1 week's time to make good my default, insofar as the same is capable of being made good, and carry on the work or comply with such direction as aforesaid in the entire satisfaction of the engineer. They should have permitted me to continue the work, and they should have given me 1 week's notice to comply and make good if there is some document which is not right. The railway shall be entitled, after giving 48 hours notice in writing under the hand of engineer to resign the contract as a whole or in part or parts, and after expiry of 48 hours notice, a final termination notice should be issued. They can resign the contract now. If I do not make good any fake document certificate which has been submitted along with the tender document, they should have given me 1 week notice. What they did is, they did not give me this notice.
Where is the impugned order?
Impugned order, 28th December. Impugned notice is 17 December 2020. It is my petition. It is on page 51, Annex G of my petition.
51.
51.
Hmm.
Lord, if Lordship may permit, let me start with the annexure D, page 40, how they gave me a show cause notice first. Page 40 annexure E, and then my reply to a show cause notice and what they have considered, Lord.
Then you are saying that notice was not given.
Milord, show cause notice, this notice was not given, Milord. They did not, that, Milord, let's, because I filed my show cause notice reply also. Milord, kindly look at page 46, annexure F.
40?
46, annexure F.
46.
Milord, 11 December 2020.
Hmm.
It is 11, dated 11 December 2020. With reference to your letter mentioned in subhead, we would like to clarify that due to the wrong credentials by one of our staff and due to time and pressure to submit bid for work mentioned in subject has created this situation. However, now Northwest Frontier Railway has verified and confirmed the genuineness of credentials submitted on behalf of Messrs. Satya Builders and having things clear about the same. We would request you to kindly consider our another work completion experience of approximately same amount issued by NHIDCL, National Highway and Infrastructure Development Corporation Limited, in favor of Messrs. Satya Builders, enclosed herewith for your kind perusal. Taking the current situation of our company, having furnished performance guarantee of amount rupees 2.78 crores approximately and EMD of rupees 30 lakhs approximately, and direct investment on site for setting up camp laboratory and finalizing field for earthwork approximately rupees 1 crore, which will be huge loss to us and also time and resources waste of NF Railway. We further insist NF Railways to verify and confirm our NHIDCL certificate regarding genuineness, quality of work and local problems handling skills and overall attitude to maintain and hand over satisfactory NHI National Highway project within time. We request you to kindly consider our plea and request to submit our said work credentials and let us continue with our already awarded work by you, and we will make sure that all the time lost in these two recent months, we will cope up with the work schedule and certainly hand you over site before time with best quality work as guidelines laid by Railway. Thereafter, annexure G, termination. I along with this letter, I submitted on page 848, I submitted an experience certificate issued by NHIDCL. Let's come to annexure G, page 51, Milord. In the impugned termination notice, they did not consider my request, Milord. Date is 17 December 2020. The above work was awarded to you by the acceptance letter number so and so, dated 2nd June 2020, on re-verification of one of the documents submitted by you in support of eligibility criteria has been found to be false. The same has been admitted by you by letter dated so and so, the reply to a show cause notice. Therefore, the above contract, void acceptance letter number so and so, dated 2nd June 2020, stands terminated with immediate effect due to your violation of para 5 and para 7B of the appendix to the tender and clause 62(1)(14) BF of the general conditions of contract. They did not mention anything with regard to my additional credentials submitted along with my show cause notice reply. The EMD, performance guarantee and security deposit submitted by you against the tender stands forfeited and shall be encashed with other dues, if any, payable against the contract. This contract will be carried out independently without your participation. Your participation as well as participation of every member partner in any manner as an individual or partnership firm JV is hereby debarred from participating in the tender for executing the work, and also you will be barred for doing business for a period of 5 years, up to 5 years. The above content action is without any prejudice to the right of the railways under tender condition or other provision of GCC 2019 or any provision of special condition of contract or agreement or under the law of the land. Milord, they did not consider in the termination notice. It was passed mechanically, Milord. They did not consider that I am willing, and I submitted a fresh certificate
How
of
can it be permitted?
Milord,
How it can be permitted?
Milord,
When you are admitting that you have submitted a false credential certificate.
Milord,
Documents.
under 62(1) BF, it has been permitted, Milord. if there is some document which has been wrongly placed, Milord, I admitted that it was a mistake of my staff.
But decision has been taken, has to be taken,
Milord,
whether
Milord,
it can be
this-
accepted or not.
Milord, decision has to be taken, but in view of the 62(1)(b) 14(f), they did not consider this, Milord. That is what I'm, Milord, my contention. Milord, I will show, Milord, and they went ahead and imposed the maximum penalty, Milord. They blacklisted me, Milord. I will show, Milord, certain judgments. I filed my written submissions also before this court, Milord. If might be permitted, Milord, some judgments. Milord, first is the judgment which I would like to rely on is, Milord has a compilation of the judgments which I have already filed.
Coalition hai. You have. This is the maybe written submission.
Compilation of judgment.
Why it's so big? This is bigger than your writ petition.
Compendium of judgment I have given separately, Milord. I have given copy. You don't have a copy? I give you.
Yes.
Milord, first judgment I am relying on is blacklisting of Honorable High Court of Delhi eminent SNP. I give it to you.
You separate it.
Milord,
You have said that you have not been provided with notice, but now you say you have shown that notice was given to you.
Notice under
Only
62(1), they have to give me 1 week's notice to rectify, Milord. They gave the notice under section they gave the notice to me under the tender document, Milord, not under special condition, the condition of a contract.
But
They-
when you are admitting that you have submitted false documents pertains to credentials.
I am submitting that, Milord. I did not say that I submitted false. I said wrong document, wrong credential. Because
Obviously, you will never say that false.
Milord, it was just
It's
because,
an admission only.
Milord, there was some mistake on the part of my staff, and I admitted. I was upfront and I informed them, Milord. Milord, thereafter, Milord, let me show the judgment, Milord.
Which judgment?
Milord, I am showing that. First judgment I am showing is SNP infrastructure and versus National Highways Infrastructure Development Corporation.
There are
copy में pending.
I have not given you last time when we argued.
Give to me.
I gave it to him, sir. You don't have copy.
Only you give me suggestion.
2019 Delhi High Court 3097. Milord, page 27 of my compendium, para 44. SNP infrastructure versus NHIDCL, Milord.
34.
Page 27, para 44. SNP infrastructure.
Yes, yes. It is well settled.
It is well settled that blacklisting a contractor has serious adverse consequences. It is common for the government and public sector undertaking to stipulate that a contractor who is blacklisted by another entity would also be ineligible to participate in the tenders invited by such entities. Blacklisting a contractor adversely affects his reputation. The Supreme Court in the case of Gorkha Security Services versus Government and City of Delhi others, 2014 9 SCC 105 has described the blacklisting a contractor as civil death. It is thus necessary to ensure that such punitive measures are taken only where the conduct of the contractor warrants such punition. Plainly, the conduct should be such that ought to render such contractor unworthy of being accepted as a contracting party. Next is para 46 on page 28, my lord. Thus, the respondent would have the right not to enter into contracts with the petitioner that is blacklisted, provided that such decision is for cogent reasons that is not capricious, mala fide or unreasonable. Similarly, in the present matter, the respondent should not blacklist the petitioner merely on the ground of a mere clerical error. The mistake committed by the workers of the petitioner is a mere clerical error, and bona fide attempt has been made by the petitioner by providing the respondent with another work completion certificate as issued by NHIDCL. The said completion certificate was submitted by the petitioner before the respondent along with the reply to
This is
the
a case of clerical mistake.
Milord,
Yours is the case of submission of false documents.
Milord, it was because it was a clerical mistake, that document, because it was during the COVID, Milord. It
Where
was
is the documents? Where is the documents which you have submitted?
Milord, it was a document with regard to the
It's not a clerical mistake, it's a documents.
Milord, that was it was submitted by the staff of Milord. I admitted, Milord.
Then
Milord, next is, Milord, Supreme Court judgment,
Isolators.
Isolators, Milord.
Then
Page 50,
page para
para 38.2,
page
page 53, page 51, 38.2, Milord, page 53. Secondly, the authority concerned has proceeded to impose a maximum penalty to the tune of 10% of the deficit supply without specifying as to why the maximum penalty was sought to be imposed. In this regard, the relevant factors as indicated by the appellant could not have been ignored altogether. Unfortunately, the High Court has totally omitted to consider this aspect of the grievance of the appellant.
50
38.2.
para page your
Page-
compilation
Page
53. Hmm.
Secondly, the authority, Milord, has it 38.2? Secondly, the authority concerned has proceeded to impose a maximum penalty to the tune of 10% of the deficit supply without specifying as to why the maximum of penalty was sought to be imposed. In this regard, the relevant factor as indicated by the appellant could not have been ignored altogether. Unfortunately, the High Court has totally omitted to consider this aspect of the grievance of the appellant. Similarly, in the present Milord, the respondent failed to take into consideration the justification provided by the petitioner in the reply to the show cause notice, even though the petitioner accepted the clerical mistake committed at the time of submission of bid and rectified the same by providing another
It's not a
certificate.
clerical mistake, sir.
Milord,
It's a submission of the false documents from the DDA or something like that.
Milord, for that, even if their own conditions specify that if there is fake document submitted or if there is something, they should give me 1 week's notice to rectify this mistake, Milord. 62B, okay, for that they have specifically mentioned in section 62V14 F that if there is a fake document submitted, you need to be rectified if the award has been given.
Okay.
Milord, next judgment I would rely on is Avinash EM Projects,
Para
38, page 78. This is with regard to quantum of punishment not proportional to the mistake committed. Para 38 on page 78.
para 38. Well settled.
It is well
High
settled
Court
that
was
High Court, while
informed
exercising power of
of
judicial
the-
review, would be reluctant to substitute its own opinion on the quantum of penalty or punishment imposed. However, where the punishment imposed is shockingly disproportionate, interference with the same would be warranted. In accordance with the above said judgment, the penalty imposed in the proportional is not proportional with the severity of the mistake committed by the petitioner. Next judgment I am relying on is Arvind Kumar.
Consider the situation where the contractor had fraudulently withdrawn large sums of money in collusion with official basis on the same being described, the contractor had been blacklisted.
The next judgment I am relying on is Arvind Kumar Singh versus State of Bihar. Manupatra BH 0342/2023.
Patna High Court.
Patna.
Let my friend to furnish me the copy. Actually,
Milord,
It's okay, you'll furnish.
all right, much appreciated.
Page 82, Milord.
Patna High Court,
Milord.
then Guwahati High Court,
Milord.
then all settled propositions. So your case is that as per clause 62.1,
B14 F. If 62.1 B F 14 F. If there is a, even if after the award has been issued to me,
if there is
there's-
a submissions of fake documents, you
No,
should
that-
be provided with 7 days time to rectify that.
Milord, this is what they have given in the general condition. of
No, no,
conduct.
according to you.
Milord,
We'll
this-
consider it.
Milord,
Are you getting me?
Milord,
According to you, as per section 62, it could have been, they ought to have been considered. Your case has been considered, that even if there is a submissions of false documents.
Milord, thereafter, Milord, then I candidly up.
You should have been allowed to rectify
Milord,
by submitting a proper documents in
Milord.
place of that.
if
So
I.
far as the credential is concerned.
Milord, thereafter, I did not deny this, Milord. I admitted it in the reply to a show cause notice that yes, there was a clerical mistake. I am submitting the fresh
It's
document.
not a clerical mistake, sir.
Milord, then they go
You
ahead
have
and.
submitted the documents. Have you not?
Milord, I have.
Then
I concede to
it's
that.
not a clerical mistake.
Milord, the penalty imposed me is like they imposed me 5 years, the maximum penalty they have imposed. They forfeited my EMD, they forfeited my performance guarantee.
So what do you want?
And they, Milord,
You should not be have been blacklisted.
Milord, I'm
It's a
not.
maximum punishment.
Milord, that is the maximum punishment, Milord.
So we'll allow. You should not be blacklisted for 5 years, right?
Milord,
Rest.
Milord, so I'll be grateful if the blacklisting can be taken. Milord.
What about the rest? Forfeiture of
Performance guarantee and security deposit.
security deposit. That they can do. Right?
Milord, they can, Milord, I leave to your lordship, Milord.
So you are only on blacklisting.
Milord.
Yes.
Milord, one more commission, Milord.
Yes.
There is a judgment which says that when the penalty with regard to forfeiture of performance guarantee or security deposit is being taken, they need to consider whether the actual loss suffered by the responding authorities. It cannot be mechanically that they impose the maximum penalty, Milord. What they did, Milord, they have not shown in the show cause, in the termination notice. They said we are forfeiting everything. They have not shown in the reply to in the termination notice, impugn notice, that what loss they have suffered. Milord, for this also I have given a judgment with regard to proportionality, Milord. Milord, kindly look into the judgment of Sushil Kumar III versus National Jute Manufacturer, 2023 SEC Online, Calcutta 3157.
Calcutta High Court.
Milord, page 126.
Okay. Okay.
Page 126.
That's all. Anything else?
Milord, I'll go down to Lordship, Milord.
So this is disproportionate.
Milord, maximum penalty, Milord, they forfeit because I mobilized my resources, Milord, I suffered losses. I mobilized my resources.
It's your own creation. You have obtained the award by playing fraud.
Yes.
By submitting fake documents or false document.
Milord, but
had you not been submitted these documents, you would not have been awarded.
Milord, had they verified at the same time, had they verified my document at that initial verification stage of a tender document itself? Milord, page 126 of this judgment.
Yes.
This says that further, the right of forfeiture of earnest money cannot survive in the absence of proof of actual loss. Forfeiture of earnest money comes within the purview of section 33 as opposed to section 74 of the Indian Contract Act, where the factum of loss is a sine qua non. That is, the seller can only forfeit a nominal amount on the seller, providing the seller has suffered loss caused to it in account of breach of contract by the buyer. Therefore, the right to forfeit earnest money cannot be sustained in the absence of any actual proof of loss. It is also important to note that where the public entity has discretion whether to forfeit any part of the earnest money, the discretion must be coupled with a duty to prevent exercise of absolute power by the repository of such power. Power must necessarily be within limits, and where the concerned authority exercises power, the discretion must be exercised with a view to promoting fairness and aiding equity. page 127, para 21. The entire earnest deposit cannot be forfeited since damages under section 73 of the Contract Act is assessed on the date of the complaint breach of the contractual term. The decision cited on behalf of respondent NGMC are distinguishable merits also. And at the end they say the existence of forfeiture clause does not imply the entire amount deposit has to be forfeited, and that the right to forfeit must be balanced against the rule of unjust enrichment, my lord. There is also a judgment with regard to blacklist. I'll submit, with regard to blacklisting, there is a Guwahati High Court judgment also, Assam Air Products Private Limited versus oil. I acknowledge and admit it, there was a bona fide mistake, I tried to rectify it and in terms of section 62(14)(b). They did not consider that, in the termination notice, they said that we are terminating the contract under 62(1)(b). But they did not consider with regard to the submission I made, I have submitted the fresh certificate. There is no whisper about it. They impose the maximum penalty upon me. And the Assam Air Products Limited Guwahati High Court judgment clearly says that an order of blacklisting has a ripple effect in that once a person is blacklisted, page 98, my lord, page para 26. An order of page 98, para 26. An order of blacklisting has a ripple effect in that once a person is blacklisted by an instrument agency of the state, he can be debarred from participation in respect of the other similar processes initiated by the state or other instrumental agencies. As a result, the blacklisted person might be precluded from entering into any business relation with the state or any of its instrumental agencies in the times to come, thus virtually resulting into his civil death. It is no longer res integra that with the blacklisting, many civil and or evil consequences follow. Blacklisting is described as civil death of a person who is served with an order of blacklisting. An order of blacklisting is indubitably stigmatic in nature and debars the blacklisted person from participating in government tenders, which prevent him from getting government contracts. The blacklisted person would not be treated in similar manner with others in the field of competition who are otherwise ought to have been treated in a similar manner. Thus, from the above authoritative pronouncement, it is clear that the consequence of the impugned order dated so-and-so of banning the petitioner for a period of 3 years has a public law elements, in that the impugned decision of banning would have the effect of not only barring the petitioner company from entering into any business relationship with the respondent company for the said period, but embedded into it also has the ripple effect of precluding the petitioner company from entering into business relationship with the state or any other of its instrumentalities, agencies in the times to come, thus resulting virtually into its civil death, at least for a period of 3 years. Even after a lapse of 3 years, it would take a long period of time for a blacklisted entity to make a revival and thereafter restore itself to its original business position in terms of reputation, volume of business, etc. It had achieved prior to being blacklisted. On many occasions, it might not even be possible to make a revival. The impugned action has adverse bearings on the freedom enshrined in Article 19 of the Constitution of India, that is freedom to carry on the trade of business subject to reasonable restrictions. A decision which impairs the fundamental right without appropriate justification can be disproportionate. It is settled that the principle of proportionality ordains that the administrative measure should not be harsher than what is necessary, and the principle of proportionality is traceable to the principle of reasonableness. If an action taken by an authority is found to be grossly disproportionate in the backdrop of obtaining facts and circumstances of the case, then such a decision is not immune from judicial scrutiny. If an action taken by the authority is arbitrary, irrational, unfair, unjust, or unreasonable, a court of law can interfere with such action by exercising the power of judicial review. The principle of proportionality as a part of judicial review ensures that a decision which is otherwise within the ambit of administrative authority must not be arbitrary, irrational, unfair, unjust, or unreasonable. Though in exercising the power of judicial review, the court is not concerned with the correctness of the decision, but while examining the decision-making process, it can very well examine whether all the relevant factors touching upon the matter.
These are all settled propositions.
Milord, so my only submission is there are 3 punishments which are imposed upon me. One is blacklisting for maximum period, the forfeiting of my entire earnest money, forfeiting of my entire performance guarantee, and apart from that, the loss which I suffered for the mobilizing my resources. Blacklisting is a bigger concern for me. I will not be able to participate in any tender document. This is a maximum penalty.
5 years. 5 years.
5 years.
That's all.
Lord, that's my only submission.
Your Lordship may kindly fix another date, Lord,
Why?
because some judgments have been referred.
Judgment.
So I have to.
These are all settled proposition.
Yes, proposition is settled. It is
These are
settled.
all settled proposition. What prejudice will cause to you by not submitting this, by furnishing the judgment? Sir, you make your submission.
Well,
What is your authority? What is the relevant clauses in the tender
Yes.
where you can initiate?
That is, that is on page number.
No. I'm asking Mr. Das Gupta. You first show us the power and authority under the relevant clauses of the SBD.
So we have filed our affidavit in opposition. And in that affidavit in opposition, we have annexed some documents there.
Hmm.
So if your Lordship come to page 97 of our affidavit in opposition,
Running page
yes, running page.
97. 97 is something else. Instruction to tender. Instruction to tenderers.
This is the page, Lord.
This is the instruction to tenderers.
Yes, Lord, that is where it is.
Page number 2, Master. 149.
Page 97, Lord, A, 5 and 7.
No, your Lordship comes to our affidavit, Lord. Affidavit. At page 67. Para 12. Page number 2. That with regard to the statement made in para 12 of the writ petition, the deponent begs to state that as per clause 7, A and B of appendix 3 of tender document, railway reserves the right to verify all statements, information and document submitted by the bidder in his tender offer. Any such verification.
Page 67.
Yes.
Running page.
Yes.
Para
12.
12, yes.
Our stand, we make it our stand. That with regard to the statement made in para 12,
This
the
is
writ petition deponent begs to state that as per para 7.
this per is also wrong. It should be E, not A.
A and B of the appendix of the tender document, railway.
Yes, sir. Is it correct or not? As per E or A?
As per. E.
It should be E or A.
E should be.
So why you have written A?
It's my mistake, my lord. I have typed it, my lord. This is my mistake, my lord.
No, that's
my acknowledgement.
Yes.
Mm.
Yes.
Clause 7, A and B of the appendix 3 of the document, railway reserves the right to verify all statement, information and documents submitted by the bidder in his tender offer. Any such verification or lack of such verification by railway shall not relieve the bidder of its obligation or liabilities hereunder, nor will affect any rights of the railway thereunder. Moreover, as per the affidavit submitted by the petitioner, as mentioned above, the tenderer is fully responsible for his correctness of the information and documents submitted by them. So paragraph 3, Miller, that with regard to the statement made in para 3 of the writ petition, the deponent begs to state that the clauses.
It's not para 3, it's para 13.
Para 13 of the writ petition, the deponent begs to state that the clause quoted by petitioner is wrong. The letter of termination of contract void letter dated 17/12/2020 was issued due to the violation of the tender condition. Void appendix 3 instruction to the tenderers. The Miller appendix 3. Para 5. That is, if any one or more of the detailed information furnished to the tenderer's document is proved to be false at any stage, the contracted harm will be debarred and then therefrom all commitments connected with the tender and their tender contract will be rejected, terminated, and further action will be taken as per extended rules. Now, para 7B. In case the wrong information submitted by tenderer, the contract shall be terminated. Earnest money deposit EMD, performance guarantee PG, and the security deposit SD of the contract forfeited. An agency barred for doing business for a period up to 5 years as provided GCC clause.
Okay, I have understood. But then how do you reconcile with this para 7B and 62.14BF?
62.14B is something else. Para, your lordship, come.
No, read this. Then, in case of any wrong information submitted into the contract shall be terminated. Earnest money deposit, performance guarantee, and security deposit or contract forfeited, and agency barred from doing business for a period of up to 5 years as provided under GCC clause 62. So how you reconcile?
62 point,
Page. What is that page?
Running page 149.
running page 149.
You read this and
Page 148. Running page.
Running page 149 F 62.1BF is
Clause 62.1.
instructions to tenderers and this GCC, General Clause of Contract.
Yes.
How you reconcile both this? No doubt you have instruction bidders you have provided. But how you reconcile this? Because it says 149, page 149. You read and please explain. Or you don't have to read, just explain.
Look, it is very much clear that when person obtained a contract by doing some fraudulent act, then he must be penalized.
Then you have to read. Read, please.
Then he must be
149.
penalized.
Please read. Sir, please read.
Hmm.
In that case, you have to
At
read and
any
explain.
time, after tender relating to the contract has been signed, submitted. At any time after tender relating to contract has been signed and submitted by the contractor. Because no such contract agreement was signed. In this case.
Hmm?
In this case, no such contract agreement was signed.
Then
It was detected before signing of the contract.
Then how you have invoked this GCC?
As per the tender condition.
No, you have said as per the GCC, which you have read in para 13.
Para?
Para 13.
Para 14.
13. 14 or 13?
14.
67.
Clause 62.1.
no page 68, running page 68, para 13 you read.
Yes.
Contract debit.
68, you have para 13, last para. For period up to years, as provided in GCC clause number 62, para 14BF.
The contract debit, running page 68.
Better.
It is a case that he has obtained contract by giving false document.
That I have understood.
And it was indicated to them.
Yes, as per
Then
the instructions to bidder, you have the power. But in general condition of contract, you have provided is 62, clause 62. You read it. 149, just directly come to the
We'll have to come to page 97. 97.
running page.
Yes. Clause 7B, subclause B.
This is the same which my
In case of any wrong information submitted, the contract shall be terminated unless one is an
In
agency.
case of any wrong information submitted by the tenderer, the contract shall be terminated, earnest money, deposit, refund, deposit, security deposit, contract agency, while doing the business period for a
That,
cycle.
that I have understood, but how you reconcile this page 149, 62, clause 62.
Clause 60, page 149.
Yes. 62, 1,
14
14B.
F. Plus 60, clause 62 1.
Hmm.
Let me read it.
Fail to give at the time of submitting.
If your lordship goes to a surplus 5, submits copy of fake documents, certificates, supports of credential submitted by the tenderers.
Yes.
So if you have submitted these things,
Then read further below.
Then in any of the said clause, the engineer on behalf of the railway may serve a contractor with a notice in writing to the effect that if the contractor does not within the 7 days after the delivery of to him of such notice proceeds to make good default so far as the same capable of being made good and carry the work completely with such documents appropriate. And I have understood. So if some document is found that is not correct, then before awarding a contract that can be done. But here what happened? Here the contract was awarded on the basis of their wrong statement. LOA was issued on the basis of their wrong statement that they have executed some work of Delhi Development Corporation. When it came to our notice, we give them a notice to submit their reply. In that reply, they had not denied this thing. They said it is the mistake of our officials who have, due to paucity of time, we could not check it. That was the stand. The document was a fake document. They want to replace that fake document by another document. Should we allow them to replace a fake document by another fake document when it is detected?
No, as per this clause, you are supposed to give him notice.
Yes, notice was given.
Under this clause.
My lord, I want to point out one thing, my lord. One thing is this, my lord. Lordship may kindly see the so-called notice, my lord. My lord, so-called notice, my lord, what happened, my lord? The tender was issued, my lord. When my lord tender was opened, my lord, he was become the L1 bidder, my lord. Now, my lord, whatever, on the basis of my lord, that, my lord, we issued the letter of acceptance, my lord.
Yes.
Only letter of acceptance, my lord. When letter of acceptance was, my lord, given to him, my lord, he has not started the work. Contract agreement was not signed, my lord. Only letter of acceptance that your tender has been accepted. Thereafter, my lord, we got the information, my lord, and we verified it from, my lord, the authority concerned, my lord, which is annexed along with this, my lord, my affidavit in opposition, my lord.
So can you invoke 62 or not?
No. No, my lord. Because, my lord, kindly come to my lord, kindly to page 148, my lord. Kindly come, my lord. It is, my lord, regarding settlement of dispute of Indian Railways, my lord. When, my lord, settlement of dispute? Once, page 146, my lord. Page 146, my lord, running case. Page 146.
Settlement of dispute, Indian Railway arbitration.
My lord, next page, my lord, 147. Arbitration and settlement of disputes shall be governed by clause 63, 64 of the Indian Railway Standard General Condition of Contract 2019 edition, which are reproduced below, subject to any correction made prior to the opening of this tender. My lord, so my lord, arbitration when it comes, my lord, after contract or agreement was signed, my lord. Now, lordship may even if come to the my lord, next page, my lord. Page 62, 1 Roman 14, my lord. First line, my lord. At any time after the tender relating to the contract has been signed, my lord. My lord, now the question will be, my lord, whether contract has been signed, my lord. If, my lord, contract has not been signed, my lord, whether, my lord, this notice can be given, my lord. So, my lord, question of giving notice under 62, 114, my lord, does not arise at all, my lord. we gave him notice before my lord signing of the contract agreement as per the tender clause, because my lord contract has not been awarded. So invocation of this clause, my lord, question of this clause does not arise, my lord. And even though, my lord, for a moment, my lord.
That is the crux.
Yes, my lord, that is the
Mr.
crux,
Das Gupta, that is the crux.
my lord. And my lord, and what is said, my lord? Even after contract.
Have you
is signed-
stated in your affidavit that this clause
lord,
cannot be invoked
My lord, you see.
and its clause is not applicable?
My lord, this clause, my lord, they never question this clause, my lord, in their writ petition, my lord. Only, my lord, this is our affidavit in opposition, my lord, where we annex all these documents, my lord, to show, my lord, how we have terminated his contract, my lord. He has never annexed these documents, my lord.
Let me comment.
My lord, you just wait. I'll not interfere you. Kindly allow me. So, my lord, and even when, my lord, whether a fraud can be rectified, my lord.
Forget about it.
My lord. So, my lord, I will not go to that, my lord, even before
So
my lord.
went on whether this can be invoked or.
So, my lord. So, my lord.
So
number
according
one-
to you, it's not applicable. It could not have been invoked.
Yes, my lord.
62.
Focus notice, my lord. Kindly come to this focus notice, my lord. We have given, my lord.
And actually page 40 of my-
Yes, page 40, my lord.
page 40 and actually
Annexary, my lord.
In case of any wrong submitted, then the contract shall be terminated.
May I read, my lord? Page 40, my lord.
Hmm.
So, for this to MS sector builders, my lord. Now, lots of dear sir, subject. LOA number, my lord. Letter of acceptance, my lord. For tender number so and so, for our, my lord, the given is given. So, my lord, letter of acceptance, my lord, in subject itself, my lord, we have given that you are given only letter of acceptance, my lord. No contract agreement has been signed, my lord.
Yes.
So, in so cause notice itself, we have made it clear, my lord. On the basis of, my lord, the LOA, my lord, letter of
The
acceptance.
builder exists by the agreement number so and so.
my lord in the show cause notice also.
My lord, kindly see, my lord, the next page, my lord. Next page, my lord. The condition, my lord, itself was quoted, my lord, here. Whether he's in so-called reply, whether he has mentioned that I am entitled under, my lord, clause 62, 314, my lord.
Because the show cause notice has been given under 62 para 14 BF also. my lord. I have replied to the show cause notice reply. my lord. In the show cause notice, they have mentioned the tender conditions, appendix 3, para A 5 and 7B, and GCC clause number 6. They are saying that it is not applicable, but they are issuing show cause notice under this.
Similarly, as provided in GCC clause 62 for and so, submission of copy of paid documents shall be in support of creditation by tender shall be entitled to be signed the contract.
They omitted the remaining
But, my lord,
part.
first,
Here I
my
can
lord,
rectify.
we have said, my lord, similarly, my lord. In GCC also, my lord, it is so that as, my lord. But never, my lord, we have said, my lord, that the contract agreement has been, agreement has been signed, my lord.
Very smart.
So, my lord, so first, my lord, we have stated that as per tender condition, my lord. My lord, the question of contract agreement cannot come, my lord. The question of contract agreement cannot come, my lord, here. So, my lord, kindly see the reply, my lord. Their reply, my lord. My lord, first of all, my lord, the my lord, credential, my lord, submitted by them, my lord, what they have, my lord, the Delhi, my lord, development authority, my lord, what did they say, my lord? My lord, we have, my lord, we have what we have stated, my lord, two sector builders, my lord, case 42, my lord. Sir, your percentage rate tender for the above cited work has been accepted. You are requested to provide, my lord, this is the Delhi Development Authority. My lord, we have inquired with them, my lord, and what we have get, my lord, we got, my lord, lordship at pay will find at page 45, my lord. Page 45, my lord.
Yes.
Page 45, to Sri K. Nara, Chief Engineer, Construction 4, Northeast Frontier Railway, Maligaon, Guwahati. If you're kindly refer to the above letter under references regarding verification of genuineness of the said credential certificate and verification certificate issued in favor of MS Satta Builders from DDA. Now, if your lordship kindly come to serial number D, my lord.
Yes,
The above mentioned word so and so.
was not issued by this office.
My lord.
Hmm.
This is the clarification come, my lord.
No, that he is not disputing.
My lord, now the
What
cause
they are
of-
trying to say is that this was a clerical mistake on the part of his employee.
my lord, now the so-called reply. My lord, clerical mistake is not a clerical mistake.
And his main grievance is you have not followed 62 clause
My lord,
60.10.
My lord,
No,
my
that's where-
specific submission, my lord.
Yes.
My specific submission is that my lord 62 does not come here, my lord. Only after signing of the contract 62 come, my lord. My lord, he can go for arbitration. He is not going for arbitration. Why he is not going for arbitration? This is an arbitration clause, my lord. My lord, as I have shown, my lord, this is an arbitration clause, my lord. He has never applied for the arbitration, my lord.
Arbitration clause will never come. It will
So,
come after the agreement, contract agreement. only.
So, my lord, if the contract agreement has not signed, my lord, question of 62, 4, my lord, does not also does not come, my lord. That is my respectful submission, my lord.
Lords, my one.
And my lord, I will show my lord, one judgment of our High Court regarding my lord blacklisting, my lord. Where my lord, all the judgment my lord cited by him, my lord was my lord,
But you are for whom?
my lord for the values, my lord.
Railways, okay.
My lord.
What happened to the contract?
My lord, now my lord, when my lord this case was moved, my lord,
Hmm.
my lord, we have my lord, the LOA, my lord, we have terminated, my lord. LOA, my lord, cancelled, my lord. He on the my lord, earnest money and other thing has been forfeited, my lord. The honorable court, while hearing the matter, my lord, has held that the forfeiture part will not be interfered by this honorable court.
Only
Because
the blacklisting.
all the blacklisted, it will be considered, my lord.
Okay.
So with regard to the tender document.
Where it is?
See, this second or the second day, my lord, it was first, my lord. My lord, I will show, my lord. Yes, my lord.
Order dated, my lords,
My lord,
24.
The interim order put on hold.
24/5/2021, my lord.
Yes.
My lord, may I read, my lord?
It is also made clear this the return of deposit bar imposed on the predecessor to business for 5 years as contained in the imprints will remain suspended.
Yes,
So
only-
the interim will be when imposed on the doing business 5 years will be in respect of this case only and it will have no consequence whatsoever so far as the legality of similar clause in other tender process of being executed in respect of you have not been allowed to participate also.
In this tender only.
Hmm.
In this tender only, but I've been allowed to participate in other tenders. my lord.
That is the
And
my lord, blacklisting part, my lord.
I gave no objection to this effect. my lord. I will not re-participate in the same tender. my lord. I
That's all.
gave, my lord.
Only blacklisting.
Only blacklisting part, my lord. remains.
No, it stays only blacklisting, but
Yes,
it
ma'am.
doesn't say anything about whether the consideration will be only for blacklisting or
No, no.
Yes,
Yes.
profession.
It did not say.
Yes,
That
ma'am.
way you are wrong.
My-
You are wrong.
my lord, only blacklisting part.
There has been stayed,
Yes, my lord. That is been only
but
that.
it doesn't say that the consideration will be only on blacklisting.
No, that has been but my lord, the forfeiture of my lord earnest money, my lord. Forfeiture part has not been interfered with. My lord, my respectful thoughts on is that, my lord. Forfeiture of my lord, that has been forfeited, my lord. We have withdrawn that money, my lord.
No,
And-
since you have already forfeited it, it may not be stay. They could not have been stay, but we can consider it.
Yes. Lots of them, sir.
Yes, what is the
Yes.
judgment?
So, my lord,
But in between, if I may be permitted to commit one thing. My learned friend is saying that it was only letter of award. Mirror, the letter of award was given on June, 2nd June 2020. And termination notice and paper notice were given after 6 months if they verify the document, not if they inform me. They're saying the contract was not entered into. They could have rejected my bid document itself. They could have forfeited my earnest money only. They waited for 6 months for me to deposit my performance bank guarantee, mobilize my resources.
You admit that there is no contract, the contract agreement. Agreement was not signed. Agreement was not signed.
Agreement, because they did not sign it. Till 6 months, I kept on writing them that please sign. They said, please proceed. Look at the letter of award. They say, please mobilize your resources, start executing the work. The time frame has been given, my lord. If I wait.
You might have apprehended that this false submission of documents may be caught.
No, my lord. Actually, my lord, what has happened?
So therefore, you were on rush to get the contract.
My lord, the only thing,
signed.
my lord, let me submit. My lord, the only thing which has happened is the petitioner is a partnership firm. Father of the petitioner passed away at that point only when he submitted for the bid document. So therefore, he relied absolutely on the staff who was filing the document. That is not merit.
You're a businessman.
Miller, I'm submitting. Miller, I'm conceding. Miller, the only thing is they waited for 6 months for me to issue a show cause notice.
No
They are saying-
clemency.
No.
We'll have to consider whether the clauses or the terms of the contract empower them to issue such a notice and determination. All right?
No.
Or whether in the facts of this case, this clause 62 can be invoked.
No.
Because your only ground is section 62 only. The rest are rest are not disputed.
Miller, that has been filed by
Except for saying that clerical mistake by
Miller, but
and a fault of your employees. That cannot be a ground.
Miller, I rest absolutely on the 62(1).
You're the principal. You're the principal. You're liable for the act of the agent.
Miller, I bow down to you. Miller, only submission is, Miller, because the blacklisting will lead to civil death for me, Miller. I will not be able to execute do any.
We'll see.
Great, Miller.
Heard, mister. That's all.
Miller, that's all. If
Mr.
you-
Dasgupta, that's all. Anything you want to add?
Yes, so far this case is concerned, did it transpire?
Obviously, we're on this case only. We're not on other
No, no, no.
cases.
Yes, because they have referred some other cases also. That is why. One thing that is very much clear that he has committed a fraud. And he has also admitted this thing.
You have not said so.
Oh, what? No, he will not say that I have committed fraud.
No,
He
you
has
have not
said
said
so,
so
it is
also.
due
I
to-
mean, the authority has not said so, that he has committed a fraud.
Authority so far.
Only simply depending on the false documents which has
What is
relied
the document they have filed?
and the false affidavit submitted, that's all.
Document they have filed that they had.
Let us not go to that extent.
They had executed some work of Delhi Development Corporation. In fact, no such work was executed by them when it was inquired. Then they volunteered to submit some other document, and that was not considered.
That is
Then-
No, I'm saying, what I'm saying that there's no finding or you're not, it's not your stand that they have fled a fraud. See, false, fake and fraud are three different and has got three different meanings and three different connotations. So which you have not said, I mean, by the authorities. You just cannot presume the higher degree of.
No, if we go through our show cause notice itself indicates. Page 14 with that. Okay. 4 digits. Yeah, page 14.
Page 40 of notification. My only submission is.
Whether you will argue or
No,
not.
no, you please.
I've heard you, it's nothing more to be heard, both of you, it's okay.
No, what I'm saying is, when they issue the termination notice, my lord, they did not consider reply filed by me, lord. When they issue the termination notice, I submitted.
Based on 62.
based on 62, my lord. They did not.
He said it cannot be invoked.
My lord, they have-
62,
But they have issued a notice, so-called notice under 62.
it's prior to
Wrong.
62.
No.
The action has been initiated and taken
My lord,
prior to the 62,
my lord,
the
My lord, so there's no.
stage
the-
of section
No,
62.
my lord, the so-called notice itself said that notice has been issued under 62.
And he said he has cleverly submitted that it says similarly.
And that
My
is
lord,
but
I
the
omitted the remaining part that you please.
That's why I said he's
That
very
part-
smart.
wrong citation.
My lord,
wrong-
but they omitted the remaining parts which was provided under 62B, 14BF.
So I'll have to consider I mean, find out the dictionary meaning of similarly.
No, the wrong citation of any clause will not cause any prejudice to us, my lord, because we had no scope.
It may not cause prejudice to you. It may cause prejudice to the
Petitioner.
Yes,
petitioner.
the question will arise when there is an arbitration proceeding. That 62 will come only in the midst of the arbitration proceeding.
So was.
Too much.
So was. Why? How?
Let me first go through this so-called notice first.
Then we'll hear after 1 month.
Your lordship fix a date. You can be.
No. I'm just on lighter note. I've heard you. There's nothing to be heard again. That's all.
No, I have no time.
What do you have argued? What do you have to argue?
So far the Chopin's notice is concerned, my lord, it has made very much clear that you have not executed any work of daily development.
He is admitting that. Who is disputing that? He said it has been wrongly furnished. There's a clerical error by his employees. He's admitting otherwise.
So whether in such circumstances, whether he deserved this penalty or not, that is the crux of the issue.
Yes. Prima facie, in such circumstances, that much of penalty may not be warranted.
Penalty of blacklisting.
Yes. See, let us not complicate the matter. Matter is very simple. Nobody is questioning the power of an authority of the respondents to terminate, to take action as per the terms of the contract. I mean, as per the terms of the tender, right? A simple case is, this is number one, you have not followed the clause 62 of the general clause of contract. Right? General condition of contract, right? Therefore, the penalty is not sustainable. Number two, even if there is, and then a penalty has to be imposed, even if you have a right, the penalty imposed is
Not
too
proportional.
excessive, it's disproportionate. That's why he's relied on some of the judgment of
So
the
far,
Supreme Court and High
so
Court.
far proportionality is concerned, I leave it to your lordship, my lord. But so far the invocation of the clause 62, my lord, is concerned, I don't think that it has any bearing whatsoever
Why?
in this case.
Why?
Because if we read it again, I don't think any bearing whatsoever. I'm telling it repeatedly.
That's why I've heard him that he said the question of relevancy, otherwise section 62 would come when there is a stage of, at the stage of arbitration.
Yes.
That is what he has said, but not by you.
Yes, sir. Then I'm obligated to him. So
And
please-
and he said, since there's no since no
that stage
contract
has
was
not come.
no contract has
Signed.
completed or signed,
Question
there's
about
no question of 62.
yes,
This stage has yet to come.
yes.
So we have applied the conditions of the tender,
Yes, yes.
not the
exactly.
condition of the not the general clauses, general condition of the contract.
permission of the tender. Not the general clause of general condition.
I think
That is.
there's a difference between the termination, the terms of contract and the terms of general condition of contract.
Yes.
What is the difference?
General condition of contract will operate only after the signing of the contract.
Is it so?
And,
Are you sure?
and there are some special contract, general contract.
No, why not go into that? Special contract would be there. What I'm saying is the terms and condition of the tender and the general condition of the contract.
Malab, usually, Malab, in the tender, when Malab contract is signed, Malab, it is written in the contract agreement that the GCC will also be followed along with this.
What do you mean by also?
Yeah, Malab.
That means
what-
it's also applied before
No,
before the contract
No,
is signed.
no, not Malab. That is what I am saying, Malab. In one Malab contract agreement is signed, Malab,
Yeah.
then only the question of GCC comes, Malab. Because in contract agreement, it is Malab, usually Malab, it is written, Malab, about the GCC, Malab. But when Malab contract itself is.
That's
not
why I'm
signed,
saying,
Malab,
what is the difference between condition of the tender and the condition of the general contract? General condition of the contract.
Malab, when it becomes the contract, Malab, when the contract agreement itself it has not been signed, Malab, it is not a contract, Malab. And even if Malab, say Malab, it's a contract, Malab, but Malab, the condition, Malab, only Malab, when Malab we Malab include the GCC in the contract agreement, Malab, then only Malab we can go for Malab.
Then you have, why you have applied 62 in your so-cause?
So, Malab, in so-cause notice, Malab, it is only Malab.
It indicates, though it says similarly, it indicates that you are also.
It is only
entitled
said,
to
Malab,
take.
similarly, not Malab suggested, Malab. Is my submission, Lordship, it's up to your Lordship, Malab. Malab, Lordship will decide, Malab. But my.
Obviously.
Malab, I can only submit, Malab, my position, Malab.
We should stop saying, I mean, submitting that it is up to the Lordship or up to the court to take a call and take a decision. Where hearing will, I mean, this way that will determine.
Malab, Lordship will determine.
It is engraved.
Malab.
So you are not supposed to submit like that.
But my
Not only you, I request the learned members of the bar, don't make a submission that it's up to your Lordship or up to the court to decide. It is always there.
My apology, Malab. My apology, Malab. I should not say that, Malab.
Otherwise, what's the use of us sitting
Yes,
here?
Malab, so Malab, my humble submission is that Malab, it is Malab only said that similarly in the 62 also, Malab. So Malab,
So I have understood.
yes, Malab.
That's all.
And Malab, in this point, Malab, I would like to Malab place one judgment of this honorable court
Saying what?
regarding Malab blacklisting. Malab.
What does it say?
Malab, Lordship mechanism. I'll read Malab from my copy, Malab. Lordship mechanism. Do you have a copy? I do not have a copy. Malab, para 15, Malab.
15. 15.
Yes, ma'am.
Patel Engineering.
The Learned Standing Council for the Railway has relied upon following case laws. Patel Engineering Limited versus the Union of India. 2. Gorkha Security Service versus Government of NCT of Delhi. 3. Judgment dated 24 to 2022 in civil appeal number so State of Odisha versus MS Panda Infrastructure Project Limited. In the case of Patel Engineering, the Honorable Supreme Court was dealing with the issue of blacklisting. It has been held that the only requirement for exercise of such power is that the same should be done fairly and rationally without in any way being arbitrary, and the same would depend on the facts and circumstances of each case. In case of Gorkha Security Services, reliance was made on the case of Patel Engineering Limited, as well as in the case of Erosion Equipment and Chemicals Limited, and it has been held that oral hearing and not necessarily while giving an opportunity to show cause as to why an entity should not be blacklisted. The Learned Council for Railway submit that even in the latest case, State of Odisha versus others, no requirement of personal hearing has been laid down as a condition precedent for blacklisting. So only, my lord, the so-called notice is enough, my lord. Rejoining his submission, the learned counsel for the petitioner submit that the requirement to follow the principle of naturalization is an admitted feature and same cannot be an empty formality. He submitted that the opportunity to substantiate the defense must be an adequate one and the safe burden can be discharged only if personal hearing is afforded. The learned counsel for the petitioner has also at this stage referred to
Okay, it's on personal hearing.
so, my lord, so-called notice has been given, my lord. So-called notice has been given, my lord, to the petitioner, my lord, and my lord, he has replied. So, my lord, the principle of national justice has been followed by the railway, my lord. And next, my lord,
It's not his case.
my lord,
It's not that he has not been heard.
Yes, my lord.
What he has said is you have not followed section 20, the clause 62.
My lord, now, my lord, now the so-called notice, my lord, once again.
Because you are supposed to provide him a chance to rectify after this so-called notice within 7 days. And then you can terminate him after consideration his reply
My lord.
after 48 hours,
My lord.
48 days,
So, my
48 hours.
So, my
Yes.
lord, my humble submission is that.
So what's the question of principle of natural justice?
My lord,
He's not his case.
on that point, my lord, I have
Sir, the ground or the issue which the petitioner has not raised, why you are raising it?
my lord, now, my lord, since my lord, my humble submission is that, my lord, terminated the contract, my lord, as per the condition of the tender condition, my lord, and my lord, where
Not as per clause, general condition of contract.
my lord, and where it is, my lord, I will read my lord.
Yes,
one
I've
second.
understood.
My lord, where it is, my lord, specifically stated that, my lord, he will forfeit the earnest money as well, yes, he will be debarred from participating for 5 years, my lord. So as per tender condition, my lord, and my lord, he has never challenged the tender condition. My lord, he has never challenged the tender. So, my lord, when he has not challenged the tender, my lord, he cannot now question the tender condition, my lord. That is my humble submission.
Heard Mr. N. Upadhyay.
Pankaj Mehta.
Pankaj Mehta, sorry. Pankaj Mehta, learned counsel for the petitioner. And also Mr. A. Dasgupta, learned counsel for the learned counsel.
No, let him argue.
No, my lord.
Actually, virtually, he has argued this.
Learned counsel.
My lord, I'm
Dasgupta and Mr.
assisting, my lord.
Mr.
Z. Goswami.
G. Goswami,
My lord,
learned counsel for the respondents.
My lord.
Hearing concluded. Judgment reserved.
Grateful, my lords. I humbly praise, my lords. Be kind.
Okay,
Grateful, my lords. So obliged.
put it there. Since he has also submitted written submission, you may also submit by tomorrow. Just one page, if your submission, if you think that, because I find that you are apprehending that this court might forget what you have submitted, because you have repeated so many.
My lord,
You have repeated your submission
yes, my lord, I'll submit a written submission. my
by
lord.
tomorrow.
But tomorrow is a holiday, my lord.
Acha, by Monday.
My lord, I'll briefly of that. my
But not that big one. Huh?
lord. No.
One
second.
page.
My-
So that your apprehension is cleared, aired out.
Well, I'm briefly of that, my lord, giving this opportunity, my lord.
Of course,
I'm-
it's a fact that we tend to forget certain submissions. Not all.
I'm grateful to you.
Grateful, my lords. So obliged.
That being said,
Sir, she said it's covered case.
From the record of the cases.
Huh?
It is not covered yet.
Okay. Why it's not covered?
Not so please to come to page 9 of the repetition.
Page 9.
Not-
Okay. Mr. Kyal is always in dispute.
No, not always. When it is necessary, only.
Always on the mode of
When I'm
adversarial situation.
Whenever I am there, it's in dispute.
Lordship, I'm not submitting, they are not serving notice to me.
Hmm.
Reason not based to them.
Okay.
And Lordship, this is incorrect statement that I'm always opposing her.
No, no, it's on lighter.
No, no,
It's
see,
a lighter.
It's a
note.
lighter
It's
note.
lighter.
when
note,
the
Lordship.
Lordship
Don't
is not
take it,
lighter
don't
note,
take it
Lordship.
seriously. It's,
Carries-
no, no, it's on lighter note.
this carries meaning, Lordship.
No, no, no.
Yes, Lordship.
At
Lordship,
least this code don't understand and don't believe all this.
Lordship, page 9.
This is me, because of this code only she said. That is,
Page
take
9.
on a lighter note.
Lordship, page 9, paragraph 7.
Yes.
I'm married. Lordship. The petitioner most respectfully beg to state that the petitioner immediately on receipt of the notice after reading the judgment had taken a legal opinion and come to know that now the notification dated 27/3/2008 and 10/6/2008 have been held to be clarificatory and have been revived. The petitioner immediately being eligible for value addition file the application for special rate value addition before the Commissioner Guwahati. Let me please note that
Which was contemplated as per the judgment of so and so, huh? But
They
it is
committed-
were within reasonable time.
because there
after
is a
passing
requirement of
judgment.
filing application before the Commissioner if they are not
Within a
for
time
spec-
frame.
for fixing a special rate.
Hmm.
There is specific statement that they submitted application before the Commissioner.
Ah,
Lordship, now Annexure 6.
page 173.
173.
Yes.
Lordship, pleased to see date is 2nd of February 2021.
Yes.
There is no signature and seal.
Hmm.
And this fact, when this fact was noticed by the Honorable Court, then they were directed to file additional affidavit.
Hmm.
Lordship, pleased to see the additional affidavit now. Page 273, paragraph 3.
Hmm. Yes.
Paragraph 3, the petitioner most respectfully beg to submit that after
Mhm.
the judgment of Honorable Apex Court dated 22nd 4/2020, the petitioner have submitted a special rate application for consideration of the value addition before the regional office of the GST in Silchar on 2nd February 24 for the period so and so. In writ petition, it is been stated by the petitioner that they are submitted before the Commissioner at Guwahati. And they have annexed some applications which bearing seal and signature.
You were just it. Where is the seal and signature?
Page 275.
Receipt.
It is there, seal is there, page 275.
Hmm.
On top.
Why two applications?
Yes, Lordship, it is, Lordship has seen earlier application, same application. Now.
2 years.
Now seal is appearing here in the page 275.
Where two copies had been annexed?
So there is one for 2008-9 and one is 2009-10. Different assessment years.
There is a specific statement in the writ petition. And this, when it was pointed out of this Honorable Court, Lordship, please to see there is an order. Observed by this Honorable Court and they were directed to file affidavit. Thereafter this affidavit was filed.
Hmm.
And as per notification of it, the application is to file before the Commissioner.
It is addressed to the Commissioner.
In fact, it was not submitted at the first place. Now, amendment has been made by the petitioner that it was submitted before the Commissioner, office of the Assistant Commissioner at Silchar.
Well, it should not be, it should not have much bearing on, because admittedly, now they are saying that they have submitted before the regional office, though addressed to the commissioner.
Pleased to see, first instance, the writ petition was filed.
No, forget about it. Apart
no.
from this,
No, Lordship, because-
definitely I'll consider.
Oh.
I'll consider your submission. All
Commissioner,
right.
Commissioner has not received the application till last yesterday.
Sir, just wait.
Lord.
Apart from this, we'll consider this aspect also. On merit,
Lord.
is it a covered case?
It is not covered case.
How?
Because Lordship, in that case, some other issues was there. Here, in that case, application was filed. It was. It
Forget
considered-
about the application.
Lordship,
Whether the consideration can be made or not.
No.
In case, if we accept that application was filed.
Lordship, please direct the petitioner to submit application before the commissioner at Guwahati. It will
No,
be
no.
considered thereafter.
That's what I'm saying.
Yes, Lordship.
Otherwise,
But otherwise-
had he been submitted the application before the appropriate authority,
It could have been considered in
is
many cases.
has he right to be considered
Yes, Lord.
in view of the judgment of the Supreme Court?
Not litigation.
No, that has been by the after the Supreme Court's
No,
decision
no,
only.
Supreme Court says that the notification was upheld by the Honorable Supreme Court.
Yeah,
Thereafter, as per the notification, they have to file application. Supreme Court has not said anything with regard to filing a special rate. Supreme Court has never said. Supreme Court, Lordship, may please to see the judgment is annexed here.
no, on the basis of that only.
No, Lordship. They are claiming on the basis of notification number.
That notification is held to be clear
upheld
picture
by
and
the Honorable
upheld.
Supreme Court.
That's why consequences follow.
No, Lordship, that is correct, but they have to file application complying with the notification.
Yes.
If they could have filed their application, it could have been disposed
So
of. by-
allow him to file.
Yes, Lordship, that can be done.
So much obliged.
That can be
That's
done.
great. Thank you so much.
Hmm.
Thank you. so
Not,
much.
not.
Not on the basis of the, we'll direct them to file
Yes,
and
Lordship.
consider as per
I'm
the.
really obliged to my
If if it is there, Lordship, then how we can object? In
Huh.
any cases, Lordship, we have disposed of the application.
So we'll say on the merit, the Supreme Court has, accepted the notification pursuant to the so and so. This court has passed some orders in some cases, including Jyoti Labs and other.
No, Lordship, Jyoti Lab is different, Lordship.
No. Factually, it may be different, but then so far as the consideration of the special rate by the commissioner,
No, Lordship.
you may reject it also.
No, that is there, Lordship. I am
That's
not
what
on
I'm
that. Whether it will be accepted, but as per notification, they have to file application within 30th of September of each year.
Yes.
Since the notification was set aside by this Honorable Court and ultimately upheld by the Honorable Supreme Court.
Yes.
So we have to consider limitation from 20th of April 2020.
Huh.
And thereafter the notification will be valid.
Yes.
So in Jyoti Laboratory case, let's see what happened. Actually, I was their counsel for the department.
Hmm.
In that case, they file application within time. That was not considered.
Hmm.
And some other period was also made there. Here, Lordship, there, the application is not properly filed. Whether it will be considered or not, it is up to the department as per the notification. If Lordship gives any direction, then it will be binding on us. Let them file application that will be considered as per law. as per
No,
the
that's what I'm
notification.
saying. This Jyoti also directed to consider
In
because there was a
considering-
file.
Lordship, that in that case, facts were different. The application was there.
Yes.
Here, application is not there.
No, application before the commissioner directly at the headquarter is not there. But then he has filed he had filed an application, the copy of the application which is submitted before the Silchar
When this
regional office.
when this honorable court intervened, then they file application and brought all this material on record. But for the first instance, they said something else.
Okay, we'll pass down. We'll direct them to, the petitioner to file an application for consideration.
Yes,
That can consider.
And
that I have already obtained instruction.
That may be considered.
we'll record the findings here in Jyoti Labs.
Lordship, then Lordship, I have some.
No. Jyoti Lab difference is that there was an application filed within time.
Yes.
So that was not considered. But then
Yes.
so far as the Supreme Court and High Court's order is concerned, decision is concerned, we'll record this also.
Yes, that can be.
And accordingly, we'll say that since the petitioner seems to have filed the application before the regional office, he is directed to file before the commissioner
Yes,
and thereafter consider
Lordship, yes,
as per this direction
yes, sir.
to
Yes, sir.
consider.
yes, Lordship. Yes, sir.
We'll not say directly it's squarely covered.
Yes, yes,
We'll
sir.
say,
Yes, yes, Lordship. Then I,
Much obliged.
is not it?
yes, Lordship.
Much obliged. Lordship.
Huh? Huh.
Much obliged. Lordship.
Heard Miss MS. N. Havalia, Learned Counsel for the petitioner, and Mr. And also and Mr. S.C. Kayal, Learned Standing Counsel,
Standing Council,
G-
CGS.
CGST. I'll pass the order today.
Not much of it.
Also pass the short order.
Not it.
I'll record, should I record your objection? That he has not filed and all this thing.
It's required, Lordship. Lordship, in 1 line or 2 line, Lordship may refer.
I'll not record it, but I'll reject it.
Because this honorable court pointed out thereafter the application.
Okay.
Much of it.
Considering her additional affidavit, we will agree that
Yes,
it
Lordship.
was filed before the original appeal. Now he needs required to be filed before
Yes,
the
sir.
commission.
Lordship.
Let's close the-
7 and 8.
Sir, what is this?
My lord, the matter relates to, my lord, constitution of the managing committee of a mosque, my lord. Now, my lord, in our petition, my lord, we have raised certain legal principle, my lord, that the religious institutions managing committee, there is no power of the government interference. Now, my lord is to decide that whether if they have
Article
to-
26.
Article 25, 26, 29, and 30 is a clear violation because, my lord, inside the mosque, there is a minority educational institution is also there, which is being monitored and controlled by the managing committee itself, my lord. That
So
is
how
the-
you are agreed by?
My lord, maybe.
Which order?
Yes, yes. If my lord, maybe I am troubling my lordships with the item number 8, my lord.
8.
8, my lord.
So 7 you have not annexed.
No, 7 is there, my lord, but.
Why 7 and 8?
Because connected, my lord. Issues are same regarding challenges in two different contexts, my lord, but 8 is more precise, my lord. That's why, my lord.
Parties are different, but the
Parties are-
issues
issues are-
raised are same.
Exactly same.
Yes.
If my lord may be pleased to take up page 72, annexure 5, my lord.
72.
Yeah. May I read, my lord? A very long and elaborate, my lord. Whereas it has come to the notice of the undersigned that there was a dharna in front of the historic Nawabi Masjid of Panbari, also known as the Panbari Masjid of Dhubri, on 19/10/2021, wherein it is observed that there is a general discontentment amongst the public regarding the running of the masjid by its existing committee. Owing to allegation of
Just
mismanagement.
wait, your existing committee.
My lord, we were, some people were there, Ahmed Ali and 10 others in the earlier committee, my lord. But
Now there's a new committee.
new committee has been formed by the government, ousting us, my lord, ousting the
So
committee.
you are agreed by that.
We are agreed, and because, my lord, as we are also associated with the welfare of the mosque, my lord. Owing to the allegation of mismanagement by the existing committee, corruption and negligence of the archaeologically sensitive and protected site of the masjid and its vicinity, the well-wishers of the masjid have expressed their concern regarding the functioning. Now, if my lord can skip the facts, but how the committee is required to be constituted starts at page 73 from clause number 1, my lord.
So you are saying that you consist of more than 10 villages, whereas by this order, the committee
Yes.
has to be consist of the
From a
10 villages only.
Only particular area. That is, my lordship is well aware, my lord. It is a clear violation of Article 15, even if we go by the merit, my lord. But from the place of origin, my lord, race and caste, they have
Will
now
hold
choose the place of
special
origin.
laws about similar- Yes.
All members of the managing committee shall be from the mentioned villages of so and so, so and so, so and so, of the religious, cultural, and social similarity. Now, who is, my lord, given the power of the government that from these villages only the committee will be, it is the community, they will decide, my lord. Now, my lord, for a, my lord, argument, my lord, if I submit, if I file a writ petition before my lordships, praying for a mandamus, that my lord kindly issue a direction for constitution of the management committee of this mosque or this church or this temple by this committee, my lord. Outrightly, my petition will be dismissed.
as it is not an Article 12 authority. Exactly, my lord, vice versa is also applicable here. Now, my lord, even after, my lordship is well aware that Article 25 gives the religious freedom of practice and profession of their own religion. Now, here is a case wherein the committee, my lord, is the foundation or the guardian of a mosque. Now, how and where the religious congregation or the other religious rituals are going to be held, it is to be determined by the committee. Now, government, by taking recourse of, my lord, law and order, they have intruded to an area where, my lord, constitutional bar is there, my lord.
Is there any regulation, law, regulation,
No,
rules
there
framed
is
by
no-
the
there is
state?
no law, there is no regulation, my lord. Even, my lord, I am also a member of our local committee, my lord. And there is no local masjid committee, my lord. There is no regulation. People convened a meeting. And from that meeting, my lord, who will be the president and who will be the secretary, it is decided by the general public, my lord. Because it is not required, my lord. In this fashion, in the state of Assam, this type of institutions, managing committees are being constituted. Now, this is the first instance in the state of Assam, my lord. I don't know in the other part of the country that the government has created a committee of the mosque.
No.
My lord.
2 weeks back, I have passed a judgment.
No, my lord, I'm sorry, my lord, I am not aware about.
Not about the masjid.
Yes, yes,
It relates to
church, my lord.
no. Some mandir, something.
Mandir, sir, my lord.
Something like that.
My lord, that facts may be slightly different, my lord, but here is, we are specially governed by Article 25, 29 and.
No,
30.
I mean, on the basis of the Article 25 and 26, I have
Allowed the petition
allowed the petition.
My
So far as the intervention
of the government.
of taking over of the institutions,
My lord. Then, my lord, I have to-
religious
Yes, yes.
institutions. But so far as intervention on the issue of law and order,
Yes,
I
yes.
have allowed.
My lord, government has the
Because
power.
Deputy
my lord,
Commissioner has the
My-
power to,
my
I mean,
My lord,
authority as a
even-
district
even-
magistrate to
even, my lord,
maintain
what-
law.
Yes, yes.
To
Even, my
prevent,
lord, what I respectfully beg to submit, my lord, even for the religious institution also, government has the power to regulate. Up to what extent, my lord, if such institution imparting education, government can fix the regulation that what type of teachers are going to be recruited or appointed. But, my lord, Supreme Court has time and again has held that the government has no power to intrude in the administration and management. Now, here is a direct interference in the administration and management of a mosque, my lord.
so basically, the by this impugn order,
My lord.
Deputy Commissioner has directed that
Committee should
the
be.
committee should be constituted,
In this-
consistent of the 10
in this
villages.
fashion, in this
According to you, there are more than 10
More
villages.
villages, people will.
25 villages,
More than
27
20. My lord,
villages.
My lord. And people have their own choice given by the constitution, my lord. That is my case, my lord.
So what is your, any judgment on that?
My lord, the judgments, I have prepared a compendium of the same, but unfortunately, my lord, one of my colleague who is in possession, his father has, so, my lord, that is the difficulty, my lord.
Huh?
Any other news?
So,
Tuesday, my lord, next coming Tuesday. May I pray for keeping as a part heard, my lord?
that is difficult in case of not able to. You find out the judgment also by this
My-
court
My, lord, I'll find
and
out,
Supreme Court judgment also.
my lord.
There's no dispute. I mean, it is settled. You cannot just interfere. You also find out any judgment,
In case of.
because there must be some judgment which I could not lay my hand,
My lord.
but then I have,
Huh?
I mean, 2 weeks, I think 2 weeks back
My lord, I will
I've
find
delivered
out.
the
I'll
judgment
find out.
from Assam only.
Yes, yes. Okay.
I was not there, otherwise I have.
No, even I am also agree with my friend that, my lord, in law and order, government can exercise BNSS. Other provisions are also there, but for the law and order committee, you constitute.
But we'll see this, the tone and tenor of the impugn order, whether it is really interference or it is not.
My lord, whether
Find
they
out.
have intruded, my lord, or not.
After a week,
Yes, yes, my lord.
not next week,
After a week. my lord.
after, thereafter. Huh? 1 week. After 1 week means not next week, thereafter.
May I pray for a date, my lord? The matter, my lord.
It's of which year?
2022, my
It will
lord.
be listed on after a week. Just give the date.
My lord.
You just find out how many cases? And it's, you will work out and give the date. Then item 11, anybody is there?
Obliged, highly obliged.
Item 11.
What is the matter? M. Burbuya.
The case of law cancelling the license for the fair price shop on the ground that the consumer is less than 50 lots.
Okay, so he has been given only one customer ID.
Or any other petitioner is not there, so what?
Yeah,
He
not
have
happy.
one opportunity loss.
May not be interested to pursue also. Which year? 2022.
Malala give one chance to them.
Okay. Non-appears to the petitioner on call. The Mr. K. Gogoi, London State Council is present. List the matter after 3 weeks.